Bilkis Bano's decades-long legal battle for justice has been extended once again. This time during a Supreme Court hearing that is listening to a bunch of petitions challenging the early release of the 11 men who gang-raped a 5-month pregnant Bilkis and killed her daughter and 7 members of her family. Today, in an unprecedented turn of events, the government, both centre and the state of Gujarat, have simply refused to tell India's highest court why Bilkis Bano's rapists were released early. In its last hearing on 27th of March, the Supreme Court had specifically asked for the files that contain the decision-making process that led to the early release of 11 men convicted of a heinous and horrendous crime. Today, the government has claimed privilege as a reason not to reveal its decision-making process and says it may file a review petition to challenge the Supreme Court's demand to see these files. The top court has also made some very strong comments on the nature of the crime, including saying today it is Bilkis, tomorrow it could be someone else. They've also questioned 1,000 days of parole granted to Bilkis rapists. The question here is the government answerable or not on why 11 convicts were given early release? Can privilege be claimed to withhold this information? And shouldn't there be transparency behind such a crucial decision that seems to have robbed Bilkis Bano of the justice that the Indian legal system gave her? Let me first play out this report filed by my colleague Harish earlier today outside court.
The Supreme Court has in fact come down heavily on the Gujarat government and the centre as far as granting premature release of for 11 convicts in the Bilkis Bano case is concerned. Justice K.M. Joseph, who was heading the bench, remarked that this was a case where a pregnant woman was killed. Not only a pregnant woman was killed, but a 3-year-old daughter was also killed, and also 7 of her relatives were killed. So how can you compare apples with oranges? How can you compare the killing of one person with mass murder? This was a case of mass murder, which prima facie did not, in fact, deserve to be left on remission. Whosoever high you are, any high authority does not have the power to grant remission in this manner. It should be ensured that such we have to examine whether the power was exercised bona fide or was illegally exercised.
I think it was very clear that it was just a delaying tactic on both the part of the union and the Gujarat government. When pressed, first he said we filed a review plea, and he said we're not showing the files, we're claiming privilege because we're going to file a review plea. When his lordship said that, well, if you're filing a review plea, what do you want till Friday? He says, well, I need to first decide whether I'm going to file a review plea. So it was very clear they were just prevaricating, and they're actually in contempt because on the 27th of March, on our pleas, it was very clearly put down in the order that all relevant files will be produced today, the next date of hearing, and they have not produced it. You saw that they were clearly in contempt. They are delaying.
All right, to speak more on this, I'm joined today by Abha Singh, lawyer and activist, Sanjay Hegde, senior advocate, R.S. Pathania of the BJP is with me on the show, and I'm also speaking with Subhash Jha, advocate. Welcome to all of you, and thank you so much for speaking with us today. Sanjay Hegde, I want to understand first from you the import of what has happened in court, because the government has come and said we don't need to place before the top court files which explains the remission process. Several months later, we're still trying to figure out on what grounds these 11 convicts were released early.
See, the point is that there is a power in the government to release people who are sentenced to life imprisonment. But that power has to be exercised in accordance with the law and in accordance with previous judgments of the Supreme Court. Now, if you just pass a boilerplate order which says nothing and says, okay, I think he served 14 years, off you go, good luck to you, then the reasons are not known. Are there reasons in the file? So the files were called for. Now the government of Gujarat and the government of India were not very sure whether they wanted to claim privilege or not. Privilege is basically 124 of the Evidence Act, which says no public officer shall be compelled to disclose communications made to him in official confidence when he considers that public interest would suffer by the disclosure. So therefore, what is the public interest that would suffer by the disclosure? That the government of Gujarat and the government of India, how did they come to the conclusion that these 11 people who were convicted of gang rape and mass murder, these are the two words, the phrases that were used. Because gang rape was committed on Bilkis Bano and there was mass murder of members of her family. Despite that, the kind of leniency that is shown to people who kill and who are involved in a single murder or some incident happens, even they have to undergo 14 full years in prison. The court was told that these people had substantial bits of parole that was amounting to nearly 3 or 4 years of parole, where they were not inside prison, and yet they, that period was counted with the time that they spent in prison to say that they have now suffered 14 years of imprisonment. And we think that they are good people who deserve to be released.
So 1 minute, just to understand this clearly, Mr. Hegde, the government has the right to release someone early. They have the right to keep that information privileged as well. So what is the concern here?
No. The government has the right to release somebody who is undergoing a sentence of life imprisonment, because life imprisonment otherwise means imprisonment for the rest of their natural life. But when you release somebody, you can't release them before 14 years because of a particular section of the law. But after 14 years, when you pass an order saying so-and-so should be prematurely released, then you have to take into account the relevant considerations. You have to take into account the kind of crime that they have been convicted for. You have to take into account the impact on society if these people are released. You also have to take into account the possible threat to the surviving victims in case somebody is prematurely released. Just to give you another example, you must remember that in the Rajiv Gandhi assassination case, after people spent about 25 years, even then in the government of the day did not release them. Finally, the Supreme Court said that release them using the special powers of the Supreme Court. And in that case, there were members of the family who had lost their loved ones who said, no, we do not want to stand in the way of a premature release. Here, on the other hand, is Bilkis Bano, who says that, look, these people should not be released. You did not ask me before you released them, and that they are a continuing threat to my sense of safety and well-being.
Subhash Jha, you know, the question over here is why the hesitation to give the reasons? The Supreme Court today, in fact, in its observations, and I have to here underline that these are observations. This hearing is still going on. 2nd May is the next hearing. But its observation has said that this is close to being contempt because they've asked for the information in the last hearing. So why the hesitation, Mr. Jha? I can't hear you, sir. I think you're on mute. I can't hear you, Mr. Jha. You have to unmute.
I'm so sorry.
Yes.
I think the highest court of the country, if seeks certain information from the government, any government, be it state government or the central government, the government will be obliged to give such information. And they can't hide the information saying that we are claiming privilege. I don't think this is an absurd argument. But I'm on a slightly different issue. The question which I would be posing to myself is this: the state, whenever there is a news concerning government of Gujarat it is highlighted. All the judgments, all the decisions taken by the government of Gujarat is found fault with, or it is considered to be flawed decision. I'm from state of Maharashtra. Now, what happened in the state of Maharashtra? There is an accused who was former MLA for 3 to 4 times he was MLA. Now, he was found to be involved in as many as 8 TADA cases. 8 TADA cases. That is the highest TADA cases against any individual in the entire country. He was found to be involved in nearly 3 dozen cases. Now,
who
he
are you
has
asking
been
this question of? 1 minute, Mr. Jha, who are you asking this question of? Are you asking of the Supreme Court that why have they taken this up?
Of course, I will be asking.
सवाल कर रहे हैं, किससे सवाल कर रहे हैं?
Of course, I will be asking the question to also the Supreme Court. What is so important for taking it up as a petition under Article 32? Why the self-imposed restrictions of Article 2 to 6 has not been taken recourse to? What happened to the High Court? Why the petitions are only selective petitions are entertained straight away in the Supreme Court? That is one of the important issues which the Supreme Court also has to ponder over someday. Why the petition was not filed in the High Court of Gujarat, and why the outsiders now the member of Parliament who spoke just now, Mahua Moitra. Now she is one of the petitioners. Now, whenever people like us approach the Supreme Court directly, we are told many times, and most of the time, they're not, that look here, you must go and exhaust your remedies first in the highest court of the state.
Like
that is the High Court. Now,
Mr. Jha, who is people like us? Who are you referring to when you say people like us?
I'm referring to myself. As a lawyer, I took the matter to the highest court of the country under Article 32 recently. And what is the issue? The issue was concerning West Bengal, mass exodus of lakhs of people from West Bengal during the course of recently held election. And then the petition was filed directly in the Supreme Court saying that, look here, this is mass exodus. The election process were all manipulated, maneuvered. Lakhs and lakhs of people have been made to run away from their own state, and then you create a situation and then you hold election. So therefore, now this is important or this is important. What is important? Let us see.
I humbly submit that today it's important to stick to the topic that we have chosen to discuss. I'm sure there might be a lot of concerns you have, Mr. Jha, but that's simply not the topic of our discussion. The topic of our discussion is what has happened in court today and what is happening with the Bilkis Bano case. So I request you to stick to that, because otherwise where are we going? Then we have to look at the number of cases filed in the Supreme Court, what gets taken up, what doesn't get taken up. And you are upset because something got taken up and something else did not. But that's just simply not what we're talking about today, sir.
As a student of law, I really feel concerned the manner in which matters are dealt with and the matters are being handled. So ultimately, I'm not the one who is representing. Someone who is representing must take a clue and bring it to the notice of the Supreme Court that, look here, there is an alternative remedy. These are the self-imposed restrictions which the constitutional courts are supposed to impose upon themselves before embarking upon.
Your grouse seems to be by the very fact that the Supreme Court has taken up the matter. But that train has left the station. The Supreme Court has taken up the matter. Today they are saying that why are you not explaining why you made a decision? Does the government of Gujarat not need to explain itself?
No, that is a different issue. I've told you.
No, but that is the issue. We are only talking about that issue. Sir, we are only talking about that issue. We can't, now suddenly you can't say I want to start talking about the weather. Because we are talking about this specific issue. This is the matter of the debate that this channel is doing this evening.
It is.
So we can't come and change that. Yes, Mr. Pathania.
It should be concerned.
Mr. Pathania, I want your response,
Tamanna, I just need a quick one-liner. Mr. Pathania, just 1 minute.
Please, sir, please.
The reason that the Supreme Court took up the issue here was the Supreme Court was approached asking that the previous policy of 1992 be used to release one convict. And because that judgment was used by the Gujarat government to justify the release of all these 11 people, Therefore, the Supreme Court necessarily had to also look into the issue of whether it had been rightly done. So it was the convicts who first went to the Supreme Court. That's all.
Okay, Mr. Patania, that was gracious of you. That was gracious of you to give your time to Sanjay Hegde. Yes, please continue, Mr. Patania.
Thank you very much. Thank you very much, Tamanna. My very, very respectful submission. The entire issue has 2 or 3 aspects. Firstly, the undisputed principle of law, and Supreme Court has said it in a number of judgments, that every sinner has a future. A big philosopher, Mr. Hegel, he says criminals can be punished for the offense, but they have a right to be honored as rational beings also. So we shouldn't detest the criminals, but the crime which they have done. So this process of reformation, remission ultimately finds a place in the Constitution of India, not only in the Civil Criminal Procedure Code. This is Article 72 and Article 100 given to the people, we the people of India, by the constitutional framers. Then Section 433 of CRPC, the part of the appropriate government. The language is appropriate government, which is being debated on the floor of the Honorable Supreme Court also. It can convert a life imprisonment into 14 years of imprisonment. So this is an issue which has already been addressed to at various levels. Not at all. Nobody wants to defend. Nobody wants to stand with. Nobody wants to have a good camaraderie with the convicts. Nobody wants to condone the crime. Nothing other. But there is a constitutional provision.
They're being garlanded,
in line
Mr.
with
Patania. They're being
please.
felicitated and garlanded. I'm so sorry to interrupt,
not
but you will continue your point. I'll pull up those pictures because you're just saying no one is,
Tamanna,
standing with them. They've been welcomed as heroes after what they've done.
That might be an individual act of an individual. That's not a party stand. That's not the party position in wholesome. That might be an individual. We don't stand by it. Neither we endorse it nor we stand by it. The other aspect of the matter remains that one more part. The entire debate, I was just hearing the Mahua Moitra announcing a judgment in the presence of the Honorable Supreme Court that the government is guilty of contempt. You see, the Honorable judges speak through their judgments only. The observations or the remarks made by the Honorable judges during the course of the arguments, they don't constitute a part of the file also. There was a petition to the Honorable Supreme Court seeking that revocation of the remarks. Then Supreme Court opined that there's nothing on record. So the entire iota of arguments and counter arguments which are flowing thick and fast in the news channels today, maybe in the print media also, they are a product of a particular comments which might have been made in a particular situation by the Honorable Judge.
I take that. I take that.
Judges speak to the judgment. Well, let's wait.
Okay, that's fine.
Let's be pensive.
The scathing comments are part of observations, but the refusal of the government to turn up on a predetermined time with files that the Supreme Court has asked for is not part of observations or comments. That has actually happened. They've come to court and said कि हम नहीं बताएंगे. Abha Singh, I just want you to comment. I'll just get a comment from Abha Singh. I want Abha Singh to comment on what Mr. Patania said, to respond to what Mr. Patania said when he's saying that every sinner must be given a chance.
He has a future.
Am I quoting you correctly?
Every sinner has a future. That's it. That's what
every sinner has a future. Abha Singh, the Supreme Court has today asked that in this case, you're applying this theory. In this case, yes.
See, Supreme Court said it's an horrendous offence. I think Mr. Patania forgets rarest of the rare offence. Here, a 21-year-old, 5-month pregnant woman gang raped her 3-year-old daughter, killed in front of her, and then you're talking of reformation. Then what happens to your encounter theory? Then why are you killing people in other states, saying, no, we have to kill them? 183 people dead. So let us not go by that. Reformation is when there is any chances of reformation. Mr. Patania, these people are gang rapists. Brutally they've killed the whole family. And the biggest issue is that legally it was not allowed, because the trial judge who had heard the case, his decision, his opinion had to be taken before remission was given. And this trial took place in Maharashtra. Not only that, CBI was looking into it. Gujarat government was in such a hurry, it did not even refer the matter to CBI, did not take its opinion. So it violated the law. Also, the committee which was set up to give remission, 2 were sitting BJP MLAs, they were party workers. So it clearly shows that it was not without bias. So and what even worries me, that Supreme Court has taken 7-8 months to even come to talk about it today. In fact, it should have taken suo motu cognizance. The day these rapists were given freedom to step out of the jail, Supreme Court should have asked and acted immediately. A time as we talk, every half an hour a woman is raped in this country, a country where women are not safe. And on top of that, if this is the message which is going to the country, that you are going to garland rapists because they belong to a particular ideology, I hang my head in shame.
We
Mr.
don't own it,
Pathania, your response.
Madam, my respectful submission, we don't own such honoring and garlanding efforts. My respectful submission, the killers of the Prime Minister of India, they have also been released on remission. So no hue and cry, no heavens fell, no such kind of energy and enthusiasm by the activists and by the people across. No briefing by Mahua Moitra and Suhashini Ali in the presence of the Honorable Supreme Court also. That's not like it. If the killer of Rajiv Gandhi has been let off, so that crime has been virtually disrespected, or the people of India or the particular government, they have condoned it. That's nothing like it. This is the process. The power of remission, the power of pardon, the power of reprieve. This vests with the president and the respective governors of the state also. And one more aspect, nobody is talking of it. This issue has already been addressed to by the Honorable Supreme Court, the 13th May 2022 order. And while hearing a review petition against this order, the Honorable Supreme Court has already addressed the issue. The review has ultimately been dismissed. 2 points.
Which issue? Which issue are you referring to on 13th of May?
One number, that's it. Point 1, that is the Gujarat government, the appropriate government. This is the appropriate government. Gujarat government is the appropriate government to decide on the matter of remission. And secondly, whether the 1992 policy has to be seen or as per the 2014 policy. Very simple.
Why
If
did
you go by
they
the
take the
2014
decision?
policy,
Today
they're
the
out of
court is
court.
asking, was there application of mind? Was the process followed? If they have the right, they've taken the right decision, why the hesitation in displaying it?
No.
Why
no
not transparency?
Tamanna. Not at all. Not once these issues have already been looked into and adjudicated by the Honorable Supreme Court. I don't know. I don't know what is the material on record with the concerned governments.
Yes, Sanjay Hegde, yes.
Tamanna, there is a dictum, justice should not only be delivered, but it should appear to be delivered. That is the biggest thing. Justice should not only be delivered, but should also seem to be delivered. Here, can you see, is Bilkis Bano getting justice? Not at all. So Supreme Court is right when it says that there was no application of mind in giving remission, and Gujarat government has absolutely erred, and procedures should be a handmaid of justice. They should not defy justice. So here
Madam,
you can't take technical reasons and give remission to them.
The perpetrators of the crime, they have already been done to justice, a full-fledged trial that even conducted outside Gujarat and completed in a record shorter period also. So ultimately, please don't use the epithet. Justice has already been done, and the punishment has been announced.
But it was a life term. It was a life term.
But converted in consonance with the principles of the law.
Sanjay Hegde wants to come in.
Article 72, Article 161
Why converted? Good behavior?
That's why the court is saying absence of knowledge. Just 1 minute. Abba Singh, one by one. Please, ma'am. Abba Singh, one by one. Sanjay Hegde is responding now. Yes.
Imprisonment for life is for the rest of your natural life. Yes, there is a question if the appropriate government, which in this case is Gujarat, decides that we can commute the sentence. But the Gujarat government cannot commute the sentence just on its whims and fancies. It has to go through a procedure. That procedure has to be reflected in the order. It has to be reflected on the files. And that the very procedure requires you to take
and that is why they don't want to show the files.
Yes, that is why kagaz nahi dikhayenge.
Nobody said it like it, sir. Nobody said.
Absolutely.
Subhash Jha, you started by saying by saying that as an advocate, you think that it's ridiculous that they're not showing the files, that they will have to show the files. Of course, what the Supreme Court finally decides is a matter that, we'll have to follow and we'll have to wait and see. But what has happened today, isn't that an unprecedented situation? Because the government is essentially, through its lawyer, saying, I haven't shown the files for two reasons. One, I plan to file a review on your demand to ask for the files. But on this day, when I was already supposed to turn up with the files, I also say I have privilege not to show it. How do you look at it as a legal strategy?
I don't agree with both the submissions made across the bar. I don't agree at all. The argument should have been something different. But nevertheless, so far as I may tell you, so far as the law on remission, furlough, parole is concerned, that needs to be streamlined. So long as we have in the statute book provisions like section 433A of CRPC, which deals with this power, which is vested with the state government. These powers are required to be, unless you do away with 433A and you say that even those who have served 14 years of sentence will not be given remission at all in a case, categories of cases. Then you categorize those cases. It's very difficult to have something in the straight jacket formula. We can't really have it because the facts and situation from cases to cases, situation to situation may differ. And therefore, it is very, very difficult. Unless and until we change the law, then there has to be a demand for changing section 433A, drop it from the statute book. Possibly no government will be in a position to make use of this. Otherwise, you take it from me that be it BJP government or for that matter, any other government in power will certainly make use of these provisions for the purpose of letting off people. There is no doubt about it.
Okay.
But so long
I
as
think that's a fair point.
we have provisions
Fair
like
point.
433A.
Your point is that process should be correct. Your point is process should be
Tamanna,
correct.
but one
Everyone
more
should explain. Yeah.
No, yeah.
Yes, Abhaji.
Also one very important point, Tamanna. A very important point is that the court has raised also that have you been fair in giving remission? What about so many people who have not even got once, who are languishing in the jail, where their matters have not been taken up? What is so special about these 11 people? That also needs to be looked into, and I'm sure they will not come up with the clear papers.
I think we're missing one, aspect of this entire case, and why this is not, as the court says, you can't compare apples and oranges. In this case, the victim is very much there in the same locality, saying that the idea of the people who perpetrated this crime on her being free and around is very distressing to her. Mr. Pathania, that's one aspect you must comment upon. You compared this to the Rajiv Gandhi assassination. Admittedly, this is a very different case because the victim in this case has to face her convicted rapists out and about.
This is a very, very humanitarian aspect of the matter. I don't want to dispute or run in face of this argument, but one of the convicts, Mr. Lala Vakil, he approaches the Honorable Supreme Court. Honorable Supreme Court refers the matter to the Gujarat Sarkar, relying upon two basic judgments of the Honorable Supreme Court that Gujarat government is the appropriate government and their cases will be dealt under the 1992 policy and not under the 2014 policy. If we go by the 2014 policy, all the 11 courts, they don't deserve remission. Under 1992 policy, they deserve remission also. This is as per the law of the land, as per the practice, as per the various parameters spelled out by the parliament and as well as by the various judgments of the Honorable Supreme Court also. The Bilkis Bano filed a review petition. Her review petition failed. And the Honorable Supreme Court and the Bombay High Court, they have also ruled at more than at one occasion. The law is as clear as day. Now, once again, let the Honorable Supreme Court come out with a detailed, with a comprehensive law, with a comprehensive final judgment. So then and only then, we shouldn't create such a furor. I was surprised by the way the Honorable Mahua Moitra, she was trying to cash in on the certain observations of the Honorable Supreme Court and trying to create a furor. She was just announcing, she just announced that government is guilty of contempt of. Oh my God, this power of punishing somebody or announcing somebody guilty of contempt of court, this lies with a member parliament who's all and out on each and every occasion. Rather, she has always her fingers on that trigger just to denigrate and defame the government.
No, but this
on,
this
very,
seems
very
like a
small
personal
impractical
problem with Mahua Moitra.
That's it,
Frankly,
that's
she
it.
is not the topic of this conversation or this story. The topic
But
of
I'm-
this conversation, the focus is on Bilkis Bano.
That's it.
You
that's it.
mentioned
But-
many petitioners.
Or rather
She
on
came
the-
and spoke
on
outside
the
court
decision-
today.
Justice for
Others did
Bilkis
not. So
Bano.
we ran the sound clip we
Justice
have.
for Bilkis Bano.
Yeah, it's
Justice
about
has been
Bilkis
done,
Bano. It's
Abasan.
not about
Just-
Mahua Moitra.
That is
You
not
see,
justice, sir.
Tamanna-
That is not justice.
Please, sir.
The
Please, sir.
point, the point is that they were sentenced to life imprisonment.
That's
There
it.
was a power to bring
That's
it down to 14 years.
That's
Has
it.
the power been justly used?
Yes, that's
That
it.
is the real question. Do you use the same power in the same manner that you would do it for an ordinary case where there was one murder? Or do you use it at the same level that no matter, it's a gang rape? No
One
matter.
very simple question,
No
sir.
matter.
But
No
it's
matter.
gang
rape and
mass murder.
It is mass murder.
Very simple
We
question,
will give
sir.
them
Very
also
simple.
14 years. That
Very simple
is
question.
an outrageous defiance of logic.
Sir, very simple question. The Honorable Supreme Court is seized of the matter. The Honorable Supreme Court is supposed to, and it shall take a comprehensive view of the matter. How can you say that the power has been unjustly exercised before the Honorable Supreme Court comes at a comprehensive
We are
conclusion? How
discussing.
can you say that justice is not
discussing. You are the
How you
one
can
who
say
said
that justice is
Because
not
those goons
How
are
you can say
armed,
that
those
justice is not
rapists
justice?
are
How you
sorry,
can
I'm
say, sir,
shocked.
please. With due respect, sir.
That's
with due
his
respect, how
view.
you can say justice has not
That's
been
his
done?
view.
That you said
That's his
justice
view,
has
Mr.
happened.
Patania. That's
Let-
his view.
Because
That's
the
the
rapists
view
are
of
roaming
the
around
petitioners.
free.
The Supreme Court. No, my point is, we haven't even come to the stage where we know what were the reasons for this decision taken on 15th August last year, which led up to the release on 15th August last year. We're at the stage in our legal process that admittedly can be very long, full of procedure and take years on end. We're at that stage where we're still trying to figure out on what grounds were they released. And that is the scope of our conversation today. That shouldn't there be transparency in understanding at least how and by what process was this decision made? We will wait to see what happens on 2nd of May. I have to wrap this leg of the debate, but I want to thank all of you for joining us and speaking with such calmness on a very sensitive and important issue. I want to thank all of our panelists actually today on that. We're taking a very short